Good evening, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications. And remember, you can always check us out on any of your favorite podcasting apps. So it's Tuesday, which means it's our Tuesday night live program. And, well, we'll talk about what you would like to talk about. Now, last week we did our show, and we did the call-in line, the number. So if you'd like to call in and talk about any case that interests you or is in the headlines as it relates to, true crime and things of that nature, feel free to give us a call. All right. Let me put the number up here just so we have that scrolling across the screen. And let's see, banners here. Let me do this. I don't see my phone number there.
It is on screen right now.
Oh, 725-228-TALK, 725-228-8255. And feel free to give us a call. Love to have you call in, have a conversation with us. It's been kind of a slow couple of weeks since the Bryan Kohberger case got resolved. Otherwise, that trial would be going on right about now. Instead, what we're getting is a bunch of piecemealing of reports and photograph in the Kohberger matter. And I said the other day on the show, if somebody is a pro Kohberger who thinks that Bryan Kohberger is truly innocent, you get head of the line privileges. You get to call in, try to convince me otherwise that he's anything but guilty, because I have to keep going back to the fact that he pled guilty in court under oath, which means that he is stating under oath that he did it. He admitted that he killed all four of those young college students and also broke into their house. Nobody pleads guilty to 4 consecutive life sentences unless they think they're going to lose big and have the death penalty. So he pled guilty. So these people that keep saying, oh, there's too many inconsistencies. Oh my gosh, the time is off by 2 seconds. There's no way that could have happened. Hogwash. He pled guilty, bottom line. And it can happen. It happened that way. And you can, people like, well, the roommates, they should have called earlier. You know what? They should have. And I look at the photos that were just released of the inside of that house. It looks like a typical college house. Stuff kind of scattered about, a beer pong table. I mean, frankly, it looks pretty good. Some of them I've been into. Most recently, I'm up at CU Boulder. I couldn't believe the living conditions of those young college students. So the one in Idaho actually looked pretty good. It looked pretty civilized in there. But the ones that I've been into for some people that lived up to the University of Colorado, oh my gosh, I couldn't believe that they, first of all, live like that. Second of all, that they demanded so much rent in those homes up there. But that's what it is in a college town. It's always going to be like that, where people always send their kids to be there and go to school, and they'll pay whatever, even if they live in total. It was just horrible. So the ones in Idaho, I look at it looks like a typical college roommate living situation. I remember going to see my daughter in college at the house that she was living in. And I think she had 4 roommates, maybe 3. I think it was 4. And who knows? I mean, it was, kind of used furniture here and there. It wasn't anything glamorous. It was just stuff around, kind of disorganized. That's what happened. You have 4 different people there. So I just don't understand why a lot of these people are, trying to criticize the roommates. Man, they're teenagers. They were drinking. They didn't know what they were thinking. They tried to ignore it, didn't want to get in anybody's business, that kind of thing. So I'm not going to criticize them in any way. And frankly, I don't think anybody should criticize them. The reality of it is that, that's just the way, that's the way it went down. And whether you like it or not, that's just the way it went down. So I wouldn't spend too much time worrying about that. And ultimately, like I said, Bryan Kohberger, um, he pled guilty. And that's the biggest thing that everyone needs to realize. And I know a lot of people are going to deny that to the bitter end. But as we brought up the other day, the thing that I think is somewhat interesting is that, what's the word I'm looking for? Everybody thought that this guy was just so weird. Everything about him was weird. I mean, really. And I get it. Everyone can say, "Oh, everybody's weird. Everybody's quirks." We read you the article of the teacher that was the Bryan Kohberger was his teaching assistant, and he's like, "Yeah, the guy's just weird." But a lot of people in academia are a little weird, and so you kind of expect that. But everybody just got creeped out by this guy, and it just makes you wonder. We don't go around arresting people for being weird and creepy. It just seems like when everything really bad and weird happens, it always comes back to the weird and creepy guy. Kind of like Bryan Kohberger, right? It's just a mess. I don't know. I'm glad it's over for the family. I know they didn't get the justice that they ultimately deserved, but that was it. He's going to have a miserable time in prison, probably not going to make it for the consecutive life sentences once he is getting out of kind of his solitary. Eventually, he's not going to be able to be in 23-hour lockdown forever. He will probably want to get out and be a little more active in prison, see if he can't make a few friends. But the reality of it is that, it's just really a bad situation for him. And frankly, I would say some people would say he deserves such a bad situation. Now, we don't want anybody to be killed, and we don't want anybody to be assaulted in the sexual way when they're in prison. There's actually crimes laws against that. It's a crime. And they make it a big deal because, they're supposed to protect people in prison. But bad things happen in prison all of the time. And we've talked about it before. There's sort of a hierarchy in prison where, obviously, it's a pretty primitive system. It's not like, oh, we're going to say, seem to be the smartest gentleman here. I think we're going to put you in charge. No, it's kind of survival of the fittest, the most powerful, and there's cliques and gangs and things of that nature. And there's a certain hierarchy. Obviously, if you're in there for murder of another gang member or something, you're going to have a certain status. And as you go down that status, if you kill women and harm women, you're on the bad list. Then you're also on the bad list if, you've done terrible things to women, like child abuse, like a battery abuse. And then certainly if you do something to children, you are very low on that hierarchy of pecking orders. I remember I had a client years ago. I represented him on a racketeering case. And this guy, he just looked like a bad dude. And his claim to fame was that he had tattoos, literally from top of his head, his entire body. And I think, we're chatting, kind of what's going on. He goes, "Yeah, I got tattoos everywhere." And he tells me, I'm like, "Everywhere?" I'm like, "Even down there?" And he goes, "Yeah." And I said, "Well, now you got me a little intrigued. What would you possibly put on that down there?" And he said, "Flames." Never got to see him. Never got to see it, which is good, but I can only imagine what it, looks like for sure. So, so anyway, that's where that stands. So Bryan Kohberger is going to have a tough time there in prison. Now, before we were getting ready to come on, I saw a story that was kind of interesting as it relates to a terrible situation in Ohio. So involved an Amish mother from Holmes County, Ohio, who's going to be charged with aggravated murder of her 4-year-old son, Vincent Miller, at Atwood Lake in Tuscaloosa County, if I pronounced that correctly. I'm sure I mispronounced it. The family of 6 was on vacation when the mother allegedly drove a golf cart into the lake with her 3 other children, twin 18-year-old sons and a 15-year-old daughter on board. The teenagers escaped unharmed, but the mother made concerning statements about conversing with God and admitting to throwing her son into the water to give him to God. The mother and her husband, Marcus J. Miller, who reportedly experienced mental health challenges and misinterpreting biblical passages, believed they needed to perform ritualistic tasks to prove their faith. So Vincent's body, the 4-year-old, was found near a boat dock on the 24th about 6 p.m. And Marcus's body, the dad, was recovered the next morning in the same area. Autopsies are pending to determine the exact cause of death. The mother is currently locked in a mental health facility, and no formal charges have yet been filed. The surviving children are now in the care of extended family. The older Amish church and the Miller family emphasizing that these actions do not reflect their teaching, attributing the incident to mental illness. Just tragedy. So apparently the mother and father thought that they had to perform certain tasks to make sure that God loved them. And the dad tried to swim out somewhere and apparently didn't make it because that was part of the task to be closer to God or something. Anyway, he drowned. So I guess they're going to rule that either an accident or suicide. And then the mother kills the 4-year-old as she drives the golf cart into the lake. I mean, wouldn't one of the first indicators be that if you're Amish and you're driving a golf cart, that's a problem in and of itself, and they're in a camper? Maybe they're not so Amish after all. We'll have to dig into that one. That's interesting. Who knows? But, yeah, I mean, a lot of stuff going on. We've got the Adelson trial as well. And I don't know. It's like we were doing amazing. I mean, Kohberger was going to be going on for like 12 weeks, and then the guy chickens out and pleads guilty. It's a good thing that he pled guilty because, saves the state a lot of time, energy, and resources, saves the family from having to go through the entire process, so to speak. But obviously, it deprives everybody from trying to figure out what exactly went on. Now, I certainly think Bryan Kohberger is guilty. I want to be absolutely clear about that. But I'll be honest with you. I mean, obviously, you got to do what the client wants you to do. But the more I read this stuff, I mean, there's some stuff in there that an attorney could have had some fun with. And, that DNA was going to be a problem. I've always said that. And people that think the DNA was not a big issue, you clearly don't know what you're talking about. DNA is always an issue, ladies and gentlemen. Remember, the government has to prove identity in every case, right? They have to prove the location that it took place in the jurisdiction in which it's charged. They obviously have to establish all the elements of the offense to the jury beyond a reasonable doubt. The elements of the crime, right? That Bryan Kohberger on about date and place charged. Took the life of, Zena Kernodle, Kaylee Gonzalez, and on and on. They have to prove that beyond a reasonable doubt. They have to prove that there's actually a victim, right? That the person was alive and now they're dead. But the most important thing, other than, the date and time, of course, but they have to prove identity. That is the most important part of any criminal case, right? We do not want to convict innocent people. That's kind of a bad thing, right? Of course it is. Nobody wants innocent people to go into custody, let alone be convicted of a crime. How do you prove identity? Well, it's great if you have an eyewitness. That's not bad, right? 2, videotape, certainly good. Certainly wasn't that prevalent when I started practicing law, which, You think, oh, the video's been around. Not, I mean, I remember practicing in the early 2000s. You were lucky if you had a video system that worked at a gas station where there was a robbery. Now it's amazing. Video is everywhere and the quality is so great. And the body cams, it's amazing how far things have come, ladies and gentlemen, in just 25, 30 years. It really is amazing. I remember watching interviews on VHS tapes, had a TV with a VHS player in the bottom. I would put it in there. Now it's all downloaded digital. You can watch it anywhere. It helps, but it's amazing. So that's what we have to do to prove ID. What's another way of proving identification, right? DNA. And so when people dismiss the DNA, I mean, that's a problem. You're not thinking in reality. Oh, it's just touch DNA. Okay, fine. That'd be great if it was your house, right? Well, of course they found Bryan Kohberger's DNA in his house. He lived there. I would be dismissive of that DNA as well. But when his DNA and his knife sheath, for example, got into the house of people that he had no apparent connection with, you can't really say, well, it just happened to be blowing in the wind. It got transferred there in the midnight air when somebody opened the window. It doesn't happen that way because he was there. Heck, I think even without the DNA, based upon the phone data, the car, his subsequent actions after the murders, I think they probably still could have got a conviction. But the DNA, that was the clincher for the prosecution. And like I said, so many people, oh, it's just touch DNA. It's DNA, ladies and gentlemen. Take it seriously. Everybody loves DNA in the criminal case. Juries love DNA because everybody thinks they understand it. Now, the stuff you got to worry about, I think, is always a little weird and interesting, is how they calculate it, right? Before it used to be, oh, the odds of it being our guy are 1 in 765 trillion to 1. And then they started this new proportionality thing. It's just, it's always funny because as more DNA samples come about, it increases the statistical likelihood that it could be somebody else. And I had an expert explain it to me one day, but basically they just have more and more people getting entered into the system. So it changes the statistical analysis. So they're always changing in way they try to explain the DNA likelihoods and probabilities that it is in fact the defendant or excluding somebody. But the reality of it is, at the end of the day, at the end of the day, DNA is a huge, huge thing for the state. Let's see here. Breaking news. Is that it, Frank? Order regarding requested redactions. Here we go. This is an order that just got posted. 8:26, 4:02 p.m. Before the court are the parties' respective responses to the order regarding sealed documents dated August 4th, 2025. Both parties object to the unsealing of the names and contact information of the potential lay witnesses and expert witnesses identified in this case. They contend that some witnesses whose identities have been publicly revealed have been subjected to harassment, threats, stalking, and other concerning behaviors by the public and media. Although the defendant has now pled guilty and has been sentenced for the crimes, the parties note that the case remains the subject to intense media scrutiny. Consequently, the parties anticipate that Consequently, the parties anticipate that revealing the identities of the witnesses will constitute an unwarranted invasion of personal privacy as provided in Idaho Code Section 74-124 and 74-101, Paragraph 17, Subparagraph A, Subparagraph II, and should be redacted pursuant to the Idaho Code of Administrative Rules 32I3A1, 3, 5, and or 7. To best balance these articulated concerns against the public's interest in access to information, the court requests additional information with regard to each witness whose name and identifying information the parties would like redacted, the witness's role in the case, whether the witness's name is already publicly known, example, known media exposure or the release of other records such as police reports, and whether the witness has been subjected to threats or harassment, and if so, the nature. Following these submissions, which is to be filed under seal, the court will review the information and either issue a written order or set the matter for a hearing. Responses should be filed within 14 days. So there you have it. Another month or so of doing this. Following this, so here he wants this done within as quickly as possible, and then another 14 days in which to respond. So really what that's saying is that let's give it another month until we do that. Let's see what else we've got here. That's the only one, I guess. Oh, there's only one up on the page there. Let's see here. Oh, these are the actual responses. State's response to court orders regarding sealed documents. Comes down to the state of Idaho, blah, 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 blah. As a general matter, beginning in the early investigation, a number of individuals associated with this case were identified, then subsequently harassed, stalked, and threatened by members of the public. The majority of the threatening behavior occurred via various social media platforms. There are also documented instances of identified individuals being physically followed and surveilled related to this case. There's also one instance of physical trespass of property and one instance of property damage, vandalism. Due to this harassment, stalking, and threatening behavior, previous identified individuals have had to take extraordinary caution, such as filing police reports, moving residents, hiring private security guards, hiring media consultants to track online harassment, and so forth. We're also aware of an individual who was inaccurately named as a suspect by a member of the public and then subjected to online harassment. In one instance, the harassment was to such a degree it led to a defamation suit. See Schofield v. Gilliard. Based on the above, the release of the full names and contact information which would identify potential lay witnesses would subject these individuals to similar harassments as described above. Releasing potential lay witnesses' names and or addresses would constitute an unwarranted invasion of personal privacy as provided by Idaho Code. And pursuant to the administrative rules, the state moves that any potential lay witness listed in any court document should be redacted, and pursuant to Rule 32, that any personal data identifiers also be redacted. The state identifies each document by date, name, and identifier in an order, and subsequently provides the state's response to continue sealing in blue, including any notice of non-objection as follows. All right, state's exhibits at sentencing. No objection. There is no objection to the unsealing of items and the order modifying the amended no contact order. All right. Opposition to motion to vacate non-dissemination order. State has no objection. Let's see. Sealed exhibit S1 to state's response to the defendant's 24 supplemental discovery request. The state has no objection to unsealing of this item, but requests the following redactions to S1. It goes into potential witnesses identified. The sheriff's return concerning witness KSF. The state believes that this was a defense filing and the state does not have a record of this filing. The state leaves the unsealing of this item at the court's discretion. Guilty plea advisory form, no objection. I think that's already been released. Notice of filing defendant's additional objections to the juror questionnaire. The state has no objection to unsealing of the item. State believes this was a defense filing. This is a sheriff's return concerning witness TAD as it related to their alternate suspect people. Order on the defendant's offer of proof regarding alternate perpetrators. The state notes that a redacted order on defendant's offer of proof, alternate perpetrators, was published on 6/26, which redacted footnotes 2 and 4. The state requests the following redactions to the unredacted order. Witnesses' names should be redacted. Exhibit W to defendant's supplemental request for discovery. They want the following redactions to W: potential witnesses' names and identifying information. State's amended notice of compliance and motion to seal the state's amended witness list. The state does not object to the unsealing of the items. However, the state requests the court redact witness list the names of all non-law enforcement and or non-lay witnesses. The following individuals are potential law enforcement, and then they list them all. It goes on and on and on. Court minutes of the closed session regarding alternate suspects. State has no objection to the unsealing of the court's minutes regarding the closed sections as it relates to the alternate perpetrators, which is going to be interesting because obviously we know the judge said you had nothing, but I would love to see what Ann Taylor said about this particular argument. The state does object to the unsealing of the court's minutes from the closed session starting at 1 hour, 36 minutes, 17 seconds to 2:07, as it involves the ongoing investigative proceedings. More than likely, that has to do with the release of information to the press that was subject to the protection order. The state has no objection to the unsealing of the court minutes from the closed session from 2:07 to 2:36, with the request that potential witness's name at 2:35:45 be redacted. State has no objection to unsealing of the state's motion to seal ex parte filings. State has no objections to unsealing Exhibit S1B, the state's response to request for discovery. State has no objection to another discovery request. Sheriff return. The state believes this was a defense filing. The state does not object to the unsealing of the items in the state's motion to amend the witness list and expert endorsements. Order sealing state's response. State doesn't object. State doesn't object. The defendant's objection to release a privileged and confidential work product. The state objects to the unsealing of this item as it involves the ongoing investigative proceedings. Depending on the outcome of that proceedings, there may be fair trial rights implicated pursuant to that. That has to do with the release of information. The state doesn't object to the unsealing of the motion seals defendant for access and objections to court's orders. Defendant's second amended phase 2 mitigation witness list. The state does not object. Order sealing the defendant's motion for order for emergency orders. State leaves that at the court's discretion. Order conditionally denying admission of additional exhibits as evidence. State does not object. Order granting defense expert analysis of evidence. State does not object. State does not object. Motion for emergency order. The state objects to the unsealing as it involves the ongoing investigation. Admission of trial exhibits, no objections. State supplemental response to defendant's 23rd supplemental request. State requests the following redactions: Bates numbers, maybe attorney work product. The pathways and AV numbers should be redacted. And that's that. So basically, for the most part, the state's saying, let the public have everything. The defense, let's see, order modifying, no contact orders, no defense, no objection. Unsealing, let's see here. Notice of filing defense additional objections to the juror questionnaires. The defense objects based upon the language under Idaho criminal administrative rules. All renditions of the jury questionnaire were sealed and not for circulations. Portions of the questionnaire contained sensitive information related to mental health and other portions containing potential witness information. The defense submits that applying to have people's names revealed, there's a continued public and media scrutiny, and therefore the questionnaire should be fine. Sheriff's return concerning witness TAD. Defense has no objection to unsealing. Alternate perpetrators. The defense objects. There's continued media attention, including social media and online sleuths and public harassment reasons. Online media reflects continued attention and comments that may be offensive and harassing and impact the safety and livelihoods of persons named. The public copy contains all pertinent information but withholds the name as is appropriate. That's interesting because, remember, she was trying to say that this was a credible, true alternate suspect. And now she doesn't want any names out there. Now, you can find the names of the people. We won't repeat them, but that's just kind of interesting. It was okay to throw his name around in court in private, but now that it's actually going to come out, obviously, we don't want anyone to be harassed if they had nothing to do with this case. People that do that, I mean, that's just, it's criminal, and it should be. Let's see. State's amended notice of compliance, motion to seal. Defendant objects. Lay witnesses' names should be released. Court minutes of recorded sessions, no objections. No court returns regarding witness YR, no objection. Defendant's reply in support of motion to access, no objection. Redact names of information. Orders sealing state's response to defendant's motion regarding special investigation. No objection, no objection. That's interesting. As it relates to the disclosures by potentially law enforcement personnel, the defense has no objection to that. And frankly, if they violate the court order, they should be held accountable. You got to follow the court rules. Otherwise, the courts have no meaning if they can't enforce the rules and people are going to ignore them. Order granting defense expert. Defense objects to unredacted release. Makes sense. State's response to defense motion for independent analysis. Objects to unredacted release and requests redactions of expert's name and address. Motion for independent analysis of evidence. The defense objects to unredacted release and requests the redactions of the expert's names and address. This request is based upon ICAR 32I3A 1 and 3 and 5, and there's continued media attention. Online media reflects continued attention and comments that may be offensive and harassing and impact the livelihood of personnel named. So pretty much as expected, and the Judge Hippler is basically saying, all right, that's all well and good, but why don't you tell me who's actually been the victim of stalking? Why don't you tell me what has actually taken place, and let me know if we really need to do that. Otherwise, this public should more than likely get it, and that's fine. It should be in favor of disclosure. The facts are out there. These experts, they were willing to get paid at state expense if they had an opinion about this particular case that they were going to testify to under oath. I think we should be able to know what their opinions are. That's my humble opinion. They were going to write a report. They were prepared to testify about it in court, but now we don't want them to have their opinions made, or maybe their opinions were so ridiculous that even now they don't want to stand by them based upon the guilty plea of the client. And hey, I understand. I've been there, ladies and gentlemen. I've been there fighting tooth and nail. And then they make you the offer you can't refuse. And you're like, oh, gee. And the client's like, I'm going to take it. You got to do what the client wants to do. And you're sitting there, little, what's the word I'm looking for? Feeling a little silly. That's the way it could possibly be. All right, let's take a look. We got some questions here. Oh, we got a call. Who do we got, Frank?
Oh, well, I'm not sure.
All right, well, we'll find out. I mean, how brave is this to take open calls, not knowing who's there or what they're going to say? Most hosts wouldn't do that. We can handle anything. Who do we have? Hello, you're on the air.
This is Cesara. Scott, how are you?
Doing well. How are you? It's been a while.
Yes, sir. I've got a couple questions spreading two cases, if you don't mind.
Take your best shot.
So, first, okay, fair enough. The Adelson stuff. It's been multiple trials. I've watched a lot of the same witnesses give testimony.
Yeah.
It seems very transparent to me, so I don't know how much argument is there. My question is, well, kind of two questions. have any of the witnesses accidentally or purposely, I guess accidentally, perjured themselves on the stands? Because they're telling the same story through so many trials for so much time that it makes me wonder sometimes. The other thing is, I guess Wendy is next. So that's the question on the Adelson stuff. I do have a comment and a question on the Kohberger, and then one other thing, sir.
Yeah, I mean, this case goes back to what I think 2014, right? So, I mean, the reality of it is there's are a lot of what's the word I'm looking for? You know, times change, people's memories fade. You know, is anyone going to be charged with perjury? No. You know, we talked about this the other day. We talked about what is necessary for perjury. Obviously, it has to be a material statement made under oath, and basically they can prove that it's, you know, falsity. And so unless they just simply got up there and said the complete opposite of their previous testimony, it's just minor inconsistencies. So no perjury.
And that's understood then.
Yeah.
Okay.
Yeah. Everybody's always.
Do you think Wendy's going to be next?
I don't know. You know, I mean, she already started today, I believe. In fact, she did. She started this morning, testifying for the prosecution. That was, yeah, maybe it was yesterday. Yeah, they all kind of run together. But she started testifying, and you know, basically, you know, her mom was very involved in her divorce and things like that. And she also has an immunity deal, meaning her statements or evidence derived from her testimony can't be used against her in any sort of future proceeding. Now, I would think, unless the mom gets really upset and wants to throw Wendy under the bus, I don't think Wendy's going to get charged. I mean, did I think she thought she knew something bad was going to happen when her brother's like, I think I'm going to hire a hitman? Yeah. But do you have a duty to go report a crime? Not really. So I think they have problems, you know, proving it. Otherwise, over the last 11 years, they probably would have charged her as well. So
after all these trials, that case just seems very transparent to me. It doesn't seem like there's a lot of question to some points at least. So I'd like to move on to the Kohberger stuff, which you started with. I believe Bryan Kohberger is just simply cooked. I have two questions or kind of comments, I guess, about him. So I deal with, I'm just an IT nerd, but I've had people in companies that I work for that were being stalked, usually women, by guys. And it gets really weird on the technical side. Like, they get their password to their phone and then a password to an email account, and pretty soon we're just helping them recover these accounts and gain control. So I'm not involved in like law enforcement or nothing like that. I'm just helping these scared girls, and it's really, really warped, some of the stuff that I see that goes on there.
Yeah.
And the guys, the only reason they have that information is because at one point they was close with the girl and they dated her or something, and so there might be, like, in my opinion, they're taking advantage or breaking trust of information that they were allowed to see. And then she says she doesn't want to see him no more. And then they freak out. So the stalking thing is just spooky as hell to me. But the other thing I want to say, I think he's cooked. I wonder, I've heard this is possible. Did they tell the judge, or who does that, if they say you're not allowed to make the money off of books and movies? Did they do that to Bryan Kohberger, or is he going to be allowed to like get rich off of his story?
So they don't have a Son of Sam law in the state of Idaho that prohibits a defendant from selling their story and making money on it. But what Judge Hippler did was he imposed a fine for each case. I think the maximum was $25,000. And then he imposed a civil fine as well of some $5,000. So the reality of it is, even if Kohberger were to get some money, the state could come in and try to garnish that and say, oh, no, that's our money to collect the fines.
Yeah, sometimes I like Idaho because we're so straight up, but sometimes I wish we had some of the other stuff. But anyway,
Yeah,
I think he's kind of cooked.
he's totally cooked.
The last thing I just want to say,
Yeah.
without trying to monopolize your show, is if I can, whenever the 8 Ball comes back up, I want to know if Lori Vallow will be free someday. I'd like to ask the 8 Ball and see, because she keeps proclaiming it.
Well,
So.
let's ask the Magic 8 Ball, since you called in. For those who don't know, when we do the Patreon shows, we haven't done Patreon in a while just because I've had some other stuff going on that I have to take care of. We do the Magic 8 Ball. All right. The Magic 8 Ball, it's kind of started off as a joke years ago. I had an associate that gave me a Magic 8 Ball. She said, for all those tough decisions, when you're not sure what to do, ask the Magic 8 Ball. And I still have that Magic 8 Ball. That one's, it's right there. And it's probably, my gosh, she's a judge now, but that young associate is now a judge. And probably 23 years ago, she started working for me. And I mean, just a great attorney. And so he did. So anyway, we always kind of ask the Magic 8 Ball. So the question is, the Czar wants to know is, will Lori Vallow ever be free? All right, Magic 8 Ball, what say you? Magic 8 Ball says, outlook, not so good. So I'd say no.
Thank you very much, Scott.
Outlook, not
I
so good.
appreciate your
But
show.
hey, well, I got you though. Let me just tell you, the stalking stuff, coincident. I finished a case today.
It's scary, man. It's scary. You should see, because I'm the IT nerd. I'm not involved, but I see just incidentally messages and stuff while I help them gain control of accounts. And it's just spooky shit, man. These guys are weird when the girl says that she doesn't want nothing to do with them.
Yeah,
normally, I don't know. It's crazy stuff.
So normally, yeah, that's it. You know, repeated following in public, monitoring, keeping under surveillance. That's kind of stalking, right? But also, like in our statute here in Colorado, if you have a protection order against somebody and then they do things, and you know, so I've got one. I resolved a stalking case this morning, and you know, classic case: boyfriend, girlfriend breaks it off. Boyfriend's like, no, I really want to, you know, still be with you, and I'm going to follow you around and, you know, do weird things, right? And so that was resolved. But I could see why, you know, the young woman was freaked out by these things. And that's one of the things, is they have to put them in basically some sort of fear, right? Or some sort, you know, it's trying to harass, annoy, alarm, intimidate, and to put this other person in fear. And so, you know, it doesn't take that much, because when you tell somebody, hey, drop dead, go away, and they still keep doing stuff, it kind of freaks you out, right? And it can escalate to simply, oh, I'm just leaving somebody flowers, or I'm going by their place of business uninvited, or they show up at all the locations that you just happen to be at.
But that
That's
gets
freaky.
weird, right?
It's
like
weird.
She said she doesn't want nothing to do with you, and you're bringing her flowers to her work. I've seen this exact thing. Like, again, I'm not involved directly.
Yeah.
I'm just the nerd in the background that's like, okay, we got to get control of your accounts. But I don't know, man. Some of these guys are off their rockers when they do that stuff. It's crazy. I always thought the bragging point was like, well, if I'm not good enough for you, fine, then I'll go find another girl. But they're way weird.
It's like they won't take no for an answer. And it's a little weird, obsessive compulsive, and probably need to do a little bit of counseling, right? And hopefully they get the you know, the resources they need. But you don't normally, it happens much more frequently than you hear about. You hear about the celebrities that are getting stalked, you know, when they actually have to go get a restraining order, or somebody, you know, gets onto their property and they have to call the police. That's what you normally hear about, you know, stalking of these fans.
In my experience, Scott, from what I've seen, it's always young kids. And to me, young kids are 21 to 25, in my own opinion.
Yep. And it's like young love, you know, usually the girl just rocked this guy's world. She's like, yeah, after all, yeah, you're not so much into you, or you got your own issues, right? And they just don't take no for an answer. And it's just kind of like, dude, you got to move on. you know. There's other fish in the sea, so to speak.
Yeah.
Right. And then
It's one of the nice things about being in Idaho. We usually have some pretty hardcore cowboys that'll let the guy know you're not welcome here. But there's guys who that doesn't work on, and they do crazy stuff.
Yeah.
So,
and then the other side that we see, we have a case where we have an individual stalking, in my opinion, is nothing else but stalking. They're involved in social media, and when they promote that they're going to do something, then all of a sudden these defamatory posts go up, and we know who it is, and getting somebody to do something, you go to court, you get TROs, cops like, hey, they're violating TRO. Well, yeah, I don't know, he's in a different state. What do you want me to do about it? Well, I want you to issue an arrest warrant. And because the point is with the stalking stuff, if somebody doesn't kind of, grab them by the neck and, like you said, the big cowboy kind of rough them up and let them know that, that's not acceptable.
Yeah,
it escalates.
You can take this to the next level, and then we'll bury you in the fucking desert. Oh, sorry, I shouldn't swear. But
that's all right.
Yeah.
Gee, I've never used that word before. I am constantly apologizing at the office for my French when I drop that word, so it's not a big deal. But yeah, I mean, the point is it escalates because they get more and more bold every time they do it, and they think they're going to get away with it. And and then it usually escalates to, I hate to say it, some sort of physical violence. And
that's what happens, Scott. And some of these guys drop off flowers with panties or lingerie, whatever they call it, right, at the girl's work. And then the cops say, well, we can't really do nothing because he hasn't, violated anything yet. And it's like, really? Well, here in the countryside, that seems like a violation. So,
well, yeah,
but it doesn't work that way,
If somebody dropped that off at your wife's office, what would you think would be appropriate, right?
I'd show up and put 2 bullets in them and then call 911 and say you got a body to clean up because I just killed it. So
yeah, no, I mean, it's that's the kind of thing that it's one of those things where, like, well,
I'm being facetious.
No, I know,
right?
I totally get
seriously,
it. I totally
it gets
get it.
spooky because it's always the younger girls too. I never see this. Well, I'm not in some sort of counseling. I only see this with younger gals who are like secretaries at offices and different stuff. I don't see it with older gals. So, but that doesn't mean much because it's not my
happens
business.
more frequently. And a lot of people, in most cases, it kind of just fades away, but sometimes it doesn't. But it happens more frequently. And I'm telling you, what it boils down to is that, there could be more cases for stalking. And, we're not talking like, hey, I want to break up with you. And the guy says, hey, would you like to get a cup of coffee? I'd really like to talk with you, see if, we got a chance to do that. That's not stalking. It's when, no, I don't care if you were the last human being on Earth and we were stuck on an island, that kind of thing. Kind of like the movie Dumb and Dumber. And then the guy says, so what you're telling me is I've got a chance, right? That's the kind of where stalking comes in. Like they don't take that hint.
I've seen messages from guys who told the father after a physical altercation in emails and stuff, who said, I'm not going to stop. She's mine.
Yep.
And those things were the worst case, right? The examples that I can come up with, but it's strange to me. It's very strange.
Yeah. And a lot of times, like I said, if somebody has a protection order and then they repeatedly violate the protection order, that can be charged as a felony in a lot of jurisdictions. It's getting the law enforcement to actually do something about it. Because they're like, well, nothing's really happened.
It's hard because they say he hasn't actually done nothing is typically what I've seen. And I'm not in some battle over this, but I've just watched it from the background, like as an IT nerd, I'm not involved in this. I'm just watching these young, pretty girls and they've got some crazy guy and it's like, dude, back off, she'll find another guy. But you can't say that. And then she tries to go to the cops and they say, well, he hasn't hurt nobody yet, or he hasn't done something that they need before they could do whatever. And so it just turns into a bunch of forms. And and then nothing matters till somebody gets hurt
until
sometimes.
somebody gets hurt. And that's the problem, is that they need to take stalking much more serious than it does, than a lot of jurisdictions do. It's somewhat frustrating. You know, like I said, I see cases. We get actually quite a few stalking cases. When I say quite a few, I'd say, you know, half a dozen a year, you know, but for one firm, that's a lot, right? And some of them that's just weird and creepy, but it's always normally some sort of relationship where one party ended it, or, you know, the divorced couple, you know, they hook up and the other one thinks, oh, we're getting back together again. And no, they just had a moment of weakness, but then they start vandalizing the car and things like that. And in today's world, you know, there's so much video, you know, you can't vandalize somebody's car and then, you know, not do it. You know, and more of the harassment stuff, like you said, it all comes down to the digital trail that people leave to do it. And that's time consuming. The police can do it.
Yeah.
They can get it under the.
It's terrible too, because then people like me get offered money to go testify on the stand, which I've always turned down. But to say, here's what you saw, here's what you did. Nope, I'll sign the form saying I helped take over the accounts, because I just don't want to be involved. I'm an IT nerd. I'm not in it for a fight, but I have to agree that some of these girls have this. On the other hand, I also have to admit that just because somebody says you did something bad, but if a guy is leaving flowers and lingerie at your work and you've told him you don't want nothing to do with him, how is that not a red flag to any sane person on the planet? I don't
exactly.
know. I don't know.
No means no, right? And it's not like, hey, would you like to go out again? Yeah, no, maybe, you know, okay, well, I'll try and, you know, whatever. But when they're like, no, I wouldn't go out with you if you were the last human on earth and we needed to reproduce. No. That is a hard no. And you got to move on. But a lot of people don't. I mean, do you think Kohberger, just out of curiosity, do you think Kohberger was stalking?
I do personally. Yep. I don't know for sure, but I believe that. I believe he was obsessed or infatuated, whatever the word is, with, I don't know, one or all of those girls or something. That's just my own opinion, but I don't have any proof of that. I think it's because he couldn't find a woman that would go with him on his own, is my own opinion. That's just me, but I don't want to sound like some perfect guy.
No, I understand. I mean, you know, there's a difference between belief and knowledge, what you believe and what you know and what you can prove, right? You know, we know that his phone was hanging around some 23 times near that residence, and he had been into the Greek restaurant that I think Madison Mogan and Kaylee Gonzalez both worked at. You know, not definitive proof that he was there stalking them, but, you know, small community, got to try the restaurant, right?
Nothing else makes much sense, Scott,
but,
to be honest with you. Nothing else makes much sense from a guy's point of view, and I don't want to say I know, but seriously, nothing else makes much sense unless you're just psycho and picking easy targets, which then how come they was so pretty when you picked them? I never saw you picking ugly targets before. So,
yeah, no, I think, you know, like I said, I don't have definitive proof unless he comes out and says I did it, but I clearly think he was stalking, clearly has women issues, and apparently had issues with just about everybody the more we learn about that guy, but clearly issues with women, creeping out a lot of them. And I'm sure they were probably just trying to be nice and whatever. And, you know, these reports of, you know, him, you know, as whether it's a TA or freaking out other students or people that he tried to, you know, introduce himself to, so to speak. Everybody had kind of a weird negative experience. Now, of course, you know, they also, most of them came forward after he was charged with murder.
She needed to walk to her car, that she needs to walk to her car because she's uncomfortable. Now I know that came out after, and I don't know any of this, but I'll tell you one thing. I've been married for over a quarter of a decade, and my wife, during some incidences, has used a phrase from a movie where she says, "I don't notice you have any accidents with ugly girls." And it's just kind of, I don't know. It just keeps it real a little
Well,
bit. So,
I don't believe in coincidences necessarily either. I've just, I've done this long enough that there's no coincidences that, when the one guy that wants to harass somebody just happens to, do it in this particular times and follows them, and the digital trail leads to that particular, route. It's not coincidence that he just happened to be in the neighborhood 23 times. I don't buy it for a second.
I agree.
He was there.
I concur. I believe in coincidence, but I don't trust them at all. I believe that they happen, but I don't trust them. So,
and I would go as far as say he wasn't stalking. I would go as far as say he was hunting. I really believe he went hunting that night, and he was out to kill.
That's the scary part,
as
right?
much as he wanted to. And that's the scary thing. Like, what does a quadruple murderer look like? Right?
Because Bryan Kohberger shouldn't fit the bill if you showed me a picture of him a few months or a year or two ago.
You may look at him and say, yeah, okay, kind of weird, creepy looking dude, probably awkward around women, probably awkward around everybody. But do you necessarily say, oh, I know that quadruple murder when I see him? No. Sometimes I do. I call it. And, a lot of times, not necessarily quadruple murders, but I think that I think I got a pretty good judge of good and evil, representing so many clients over the years. You can tell the people that were an aberration. They made one bad day should not necessarily, define them, right? But there's some people that are just downright evil, and I can see it. I can feel it. It's usually something in their eyes. I can tell.
I'm glad I'm in a line of work where I can't see that in people still, even though sometimes I might wish I had that insight. I'm glad I haven't had to do that and have your experience. So I thank you for what you do and who you are, sir.
Yeah. This is a little, not to get too sidetracked, but represented a guy years ago, and I won't go into specifics, but he had another case, and a different attorney represented him on that case. And I saw that attorney, and he, I've known him, and he goes, hey, they're doing post-conviction on me in this case, and the guy was, outraged and whatever. And literally at the same moment, we both said, that guy is evil, the two of us at the same time. And this attorney, he's been practicing longer than I have. He's probably close to 45 years. And he was just like one of the scariest dudes I've ever met. And I said, I totally agree with you. And I remember that there was a video of something that took place, and it was horrific. And I had a female associate that worked with me at the time. And after watching that, she came to me like, she told me like a couple weeks later, she goes, I had to sleep with my light on because it freaked me out so bad. And she's like, I will not meet with that client alone. So I always went, with her, which is always good when you have a client like that. But the guy was just pure evil. And of course, he's trying to get out.
I'm so glad that I get to spend my profession and my career behind a monitor and a mouse and a keyboard for the most part. I'm happy to be an IT nerd when you put it that way.
Some days it's, this is interesting. Some days it's some days it's fascinating. Other days it's just like, why am I doing this? I should go do something else. But there's always something intriguing about every case and every client. And, I've represented lots of people that have been accused of murder, convicted of murder. And it's funny because some of them don't look like evil, but they got a real dark place in their heart. And others are just like, I was a one-time thing. I lost my emotions. I was stupid. I was being young. But, there's consequences to all of those actions. But I'm telling you, when you see evil and real evil, and I could probably count it on one hand where I thought true evil, not just like
Well,
that's
I'll
a
tell you
bad
this.
dude.
I know you were an officer in the Marines. I was enlisted in the Navy. So it was one vet to another. I'm glad there's guys with your brains out there figuring some of this stuff out, because I just take care of my little corner and do my little piece and then report on up and down, even sometimes if I don't agree with the, the decisions of the structure.
No, hey, I understand.
Thank you for who you are and all that you do,
All
Scott.
right. Well, thank you. Thanks for your service.
You have a good evening, sir.
All right. You too. Let's see here. Let's take a look at some of these things here. We're having trouble streaming to Facebook. We're not on Facebook this evening, huh? Let me see if I can I'm gonna go back through. Let me see here. Bill Thompson was hit me. I said he never visited there. Why does he keep lying? He thought we're smarter than everyone else. Not true. 57 stab wounds in that one girl. That's anger. I totally agree, Sally. We had talked about that at one point. That is absolutely true. That is just pure anger. That's personal, right? It's kind of like strangulation. That's personal. Stabbing somebody 57 times, that's personal. That's not just, I went in there and I tripped and I just happened to stab somebody 57 times. It was an accident. No, that is intentional. That is after deliberation with no doubt. Let's see here. Let's see here. I'm just seeing if any questions here that really jump out. Yeah. It's like everybody having conversations amongst themselves, basically. But that's all right. Thanks, chat, for putting up with it. Jennifer finally caught alive. That's great. Cesar, I thought that was a good call. Good questions. And we got to do the Magic 8 Ball for the people who hadn't received it. So I guess before we sign off here, we should probably but I digress. I caught alive. Yay. If anyone wants to ask the Magic 8 Ball one more question before we sign off, put it in the comments and we'll see. Magic 8 Ball is usually right. The question Tazara wanted to know was Lori Vallow ever going to be free again? And the Magic 8 Ball said, I think the response was not looking good, something to that effect. So yeah, Magic 8 Ball is normally correct. If you can't trust the Magic 8 Ball, who can you trust? Well, other than Scott Reich, I'll tell you the way I see it. I have no reason to lie to anybody. Just tell it the way it is. And particularly as you get older in life, you just tell it the way it is. You don't have time for the BS. You got to just say what you think and be truthful about it. Obviously, be able to have support for it so that you can stand up to scrutiny and cross-examination. Absolutely. But, I just find over the years, man, just give it to people straight. They'll appreciate it. You'll appreciate it because you're not tap dancing around and like, oh, I can't say this. I'm going to hurt somebody's feeling or something to that effect. It's just, I've learned in the practice of law, here are the facts. Here's the good facts. Here's the bad facts. And here's the ugly facts. And we can't ignore the ugly facts. And I just think learning that over the course of my career, it just helps you be much more direct and forthcoming as it relates to everything in life. And, I understand you don't want to hurt people's feelings, but sometimes you got to know the truth. And sometimes if their position is just makes no rational sense, they should probably be told why they're wrong. right? And somebody told me the other day, they were asking, I was asked to be a mentor. I've done it for years at the law school. And I asked the young lady, why do you want to be a lawyer? Well, my parents always told me that I was good at arguing. I said, well, being somebody that can argue does not make you a good lawyer. What makes you a good lawyer is that you have to be persuasive in what you're trying to convince somebody of doing, not just, I'm right, you're wrong, I'm right. That's not persuasive. That's just saying, I want to argue with you. You have to be able to back it up with facts, applying those facts to any kind of rule of law. That's what lawyers do, right? Here's the law. Here's the facts. How do we apply these facts to the law? That's it. And so, I just thought it was interesting. Well, my parents always said I like to argue. I should be a lawyer. Okay, but how persuasive are you? Because that's what you have to be. You have to be persuasive to the client. Hey, I think this is a good disposition. I think you should resolve your case. Hey, Mr. DA, Mr. Opposing Counsel, this is what we need to do, right? This is why we're right. This is why you're going to lose. This is why you should give us what we're asking for. Not just because. You got to go beyond the because. All right, got one more call. Who do we have? Larry, you're on the air.
Yes.
How are you doing?
Yes, I'm here.
You're on the air. Go ahead. Where are you calling from?
I'm sorry, I'm having trouble here.
All right.
Can you hear me?
I can hear you fine. Go ahead. Are you there, Larry? All right. Well, it seems like we lost Larry.
Yeah.
All right. Well, sorry, Larry. Feel free to call back. Will BK get prison justice? Great question, Donna. Oh, let's see. Man, I wish we had a close-up here on the Magic 8 Ball. So we got the Magic 8 Ball. Magic 8 Ball. Will Bryan Kohberger get prison justice? Magic 8 Ball, we shake it, and the Magic 8 Ball says, oh, without a doubt. I don't know if you can see that. Without a doubt. Can you see that there? Is that other camera on, Frank? All right. It says without a doubt. Magic 8 Ball. And just remember, it's kind of like Dahmer, right? It's not going to be necessarily tomorrow, next week. It could be 5 months, 6 months, a year, 6 years from now. But somebody will come up and, be walking along and all of a sudden, oh, sorry. All right, we got one more call. London?
Yeah. Apparently.
Hello, you're on the air, London?
No, this is Yolanda.
Oh, Yolanda. The computer said London. Sorry. Go ahead. What's on your mind?
It's okay. It's okay. I go by Yoli on the YouTube. Yoli.
Okay.
I'm an
Okay.
attorney.
Oh, great.
Yeah.
So what's on your
Yeah.
mind?
So you're talking about the Kohberger case, right?
Yes.
Yeah. So I wanted to know what you think about DNA not being tested. DNA that was found in the home
Mm-hmm.
where the unalighting or where the murders occurred.
Well, I would think as a defense attorney, if that case had gone to trial, they would have tried to make a lot of hay about that. But
Right.
normally what takes place when you get the crime scene people that they come in and they investigate, they say, we collected these items and this and that. And then you bring in the lab people that say, yes, I was asked to, do a DNA analysis on this unknown sample, or they've tested it by then to, known to be blood, or they swabbed the knife sheath or something along those lines. Right. And so obviously DNA is expensive. So DNA is expensive, and there's only so many hours in a day. They can't test every little corner handle desktop in the entire house. So what happens then is the detectives talk to the lab people, and the lab people say, this is what I think is the best result to get a sample. Obviously they swabbed the sheath. As my understanding, they did, the outside, they did the button, and that's where they got, the DNA.
Well,
but
we have to look at the transcript. We have to look at the transcript to see if they swabbed the outside, because I'm sure they did.
And maybe I don't think I'm making that up, but I could have swore I remember them reading. Maybe it was a testimony or something at one of the hearings, but they said that they swabbed the outside of the sheath, and then the button, and then the inside as well.
Well, that's okay. I mean, it's been going on for so long that our memories are shot. But what I do want to say, did you see the body of the officers that was just released?
Which one?
The body cam. It was the body cam of the first.
Oh, when they first responded, yes.
Yeah.
And talking to all
did you know
people outside? Yeah.
And I just want to know what you think about that, because I have a lot of questions about that body cam. But I want to know what you think about that as a criminal defense attorney.
Well, I mean, the cops show up, people are outside, they'd been inside. They didn't immediately kind of separate people. They didn't, kind of isolate the scene as well as they could have. I was it originally the best kind of separate witness, cordon off the scene? No, but in all fairness, I don't think they truly realized what they had at the moment based upon the descriptions that they got from the people at the scene.
Okay, so understood. But did you see the video cam where the knife is, where the beer pong table is shown, and then they show the officer walks by, he walks back, and there's no knife on the beer pong table, and then all of a sudden this knife appears, and it looks like it looks like a rusty knife to me, but it just appears. Yeah,
I saw the knife on the beer pong table. It's like almost looked like a sharp, almost like a letter opener kind of thing, but it wasn't. It was like a knife. Yeah. Yes, I remember seeing that. I don't remember seeing that it disappeared or it wasn't there and then it was. But more than likely, because I saw a still photograph of it, and I don't believe that was taken from a body cam.
Well, trust me, if you watch the body cam, you'll see it's not there initially, and then it appears after the fact. But what I want to say is, in this case, have you ever had clients who have decided to just plead guilty because it was just way too much? The exposure of their life was just too much, and they just decided to plead guilty. And I don't want to make clients, of course, because that's client privilege, but have you ever had that happen?
Absolutely.
Okay.
Absolutely.
But
normally when they take that deal, they're not doing it because they're necessarily innocent. Okay. And I always tell clients, you shouldn't plead guilty to something if you didn't do it. We're not talking like you're getting a speeding ticket and they offer you a defective headlamp, right? Anybody will take that disposition, right? Your 4-point speeding ticket, we're going to offer you a non-moving 2-point that's not going to affect your insurance. Yeah, I'll take it, right? Makes complete sense. But, I mean, I handle lots of serious felonies, from murders to first-degree assaults to sex assaults on children and things of that nature. And, we're not talking stuff that, well, I'm totally innocent, but I just feel like I just got to take the deal, right? I always tell clients, don't plead guilty to something you didn't do, particularly like that, right? Are you going to have prison exposure? Are you going to be a registered sex offender? Are you going to go to prison and have to serve 85% of the time? don't do it. Now,
Mhm.
it's ultimately the client's decision, but normally when they're like, I didn't do this or whatever, and then it usually comes out like, okay, well, maybe I was kind of there and did it. And yeah, they're offering me,
Mhm.
a second-degree assault instead of attempted murder. You mean that's not a crime of violence? And I'll be out in like 5 years? Yes. Yeah, I'll take that. That kind of thing.
Right.
But
So
that,
assume that well, wait, I want you to assume that because Bryan Kohberger has a history of substance abuse, we know that. That's pretty much out in the open, that he kind of fell back into that. And because he might have been in the area to obtain substances, perhaps this happened while he was in the area. Would that be considered felony murder?
no. Felony
Okay.
murder is when, for example, you go and rob a convenience store and there's, I'm going to drive the car. You're going to go in and rob the store. And the guy that goes into the store shoots the clerk and dies. That's felony murder. The guy in the car can be held responsible for that. Even if the guy has a heart attack, basically somebody dies in the commission of a enumerated offense that the legislature has deemed to be dangerous. So, arson,
Right.
burglaries, robberies, things of that nature. But just being in the neighborhood, just walking by, no, mere presence in and of itself is not evidence of guilt. I ask for those instructions all the time. Mere presence at the scene of the crime doesn't indicate necessarily that one is guilty involved in it. So, yeah.
Right. So you have heard the prosecutor saying, Bill Thompson saying that they had nothing, they had no murder weapon. They had no connection to the house or to the victims. They had no connection to the victims. They had no connection. They couldn't put him in the house, period. And when a prosecutor is saying that, what comes to your mind as a criminal defense attorney?
I would say in a case like this, give me life without parole.
Okay. And you say that why?
Because, they did have him in the house. They had the roommate saying they identified, somebody that looked like Kohberger. And that would be subject to cross-examination and the jury could disregard it or not. But more importantly, they had the DNA evidence on the sheath under the body. How did that get there?
Yeah. DNA is very powerful. I totally understand that.
Mm-hmm.
It could case every day, but but assuming that it's explained properly, that it was trace DNA and that it was a movable object, and you really can't tell when the DNA was placed on that knife sheath.
I can ask that. I don't care whether it's, somebody spit on it and you saw him do it. You can tell the expert on cross-examination, they will agree with you every time. Unless you were there and saw somebody do it, or it's on video and you have a date stamp, they will tell you, we cannot tell you how the DNA got there or under what circumstances that it got there either. And, you can say, oh, it's just trace DNA. Oh, it's his DNA. I don't care how.
Yeah.
That's the whole point of DNA. It is so tiny, so minute that it's there, that it is, you can't, it's there. And unless you can explain how it got there, you got problems. Now you could say the real killer must have planted this in the frame, Bryan Kohberger, but then you've got all the other stuff like his car, his phone going off, as he head over there to Idaho.
Yeah. So his car, in my opinion, if you have to have an expert, an FBI expert, and you need two experts to identify his car because it's not clear on the video and there's no license plate, that to me is reasonable doubt.
Okay. But you're an attorney. What kind of law do you practice?
Yes. Look, I practice civil law. I'm a medical malpractice attorney, but I got the highest grade in criminal law.
All right.
And that answers, that's why I'm thinking the way I'm thinking.
All right. Well, And I would say he confessed. He pled guilty.
Yes, yes.
Okay.
And that's
He did it. And I understand if had they gone to trial, everything that people are bringing up is, oh, look at the minor inconsistency. That's it.
Yeah.
But I see that all the time where clients will
Yes.
say, you know, they said that the perpetrator had on a, dark blue shirt. Well, my shirt wasn't dark blue. It was teal. Right. And,
no,
they're like, the witness is lying. They should be charged with perjury. That's it. And it's like, but okay. They got their hues of color mixed up, but all the other evidence in and of itself, and that's not your biggest problem. And that's what I think people get wrapped around the axle is you can say, oh, well, what about this one little piece? Okay, but is that one little piece in and of itself enough to raise reasonable doubt? And remember, reasonable doubt is not a vague, imaginary, or a speculative doubt, but a doubt that would cause people to pause in matters of great importance to themselves. And if you say you got this big old stack of evidence, stack of papers this high, and you pull out one sheet of paper that says, they had two experts. They obviously, if they don't know, and the prosecution's going to say, we have two experts to come up with the same conclusion, and they're going to try to insinuate, and the defense had experts. How come the defense didn't have any experts to say that wasn't his car?
Well, we don't know that because the expert disclosures are sealed.
Well,
so
we went through the orders tonight. Most, if not everything, should be hopefully unsealed with their names redacted. But what they were going to say will come out. I don't think that they had an expert to say that wasn't his car.
Well, just as a juror, like put my attorney training aside, just as a juror, and I have dry eyes, so I kind of have bad eyesight. I can't tell. I can't tell. And look, you should be able to see it. It's probably because of the video. There's a bunch of white cars. I just see white car. I don't know. But my the real reason why I called in is because I'm so confused. I don't know. Like, he pled guilty, and so I get it. I think he had something to do with it. But do I think he committed the murders? I'm confused. So I talk about you. I have a channel, and I also say, I rely on criminal defense attorneys. So when somebody pleads guilty to this, who has a disability, well, not just the disability, but a psychiatric disorder, which is obsessive compulsive disorder, does the judge have to take into consideration when he asks the defendant, are you of sound mind? Are you aware that you've been diagnosed with autism spectrum disorder? Are you aware that you've been diagnosed with obsessive compulsive disorder? And to get those answers from him and then ask, is this affecting your ability or is this affecting your decision to plead guilty? So that's my question.
Well, I think the judge did ask if you've been diagnosed with
No.
anything.
No, he said, are you of sound mind?
Okay. Are you of sound mind? Are you aware what's going on? Listen, they restored people to competency that were legally not competent, right? They couldn't appreciate right from wrong, all those types of good things. They get restored to competency and they can ultimately be tried for a case. I have clients that the judge will ask them, have you taken any prescription medication, street drug within the last 24 hours? And they're like, oh, I'm on Zexapro, Zoloft, blah, blah. And they, list like 6 of them. And they're like, does that affect your ability to understand what's going on here today? And they're like, no, actually it makes me feel better. Right. Just because you have a disability, just because you have, heck, if you want to talk about disabilities, most of the people that are in the criminal defense world, defendants, have some sort of mental health issue, whether it be bipolar, depression, they're self-medicating for some issue that they have. I mean, that is the bulk of it. if that were the case, we're like, oh, you could be on the autism spectrum disorder. The man was attending a PhD program. There's nothing that's going to affect his ability to understand what's going on in the courtroom there today. Heck, he probably understood more of what was going on than most of the people sitting in the gallery.
No, not at all. The autism spectrum disorder, based on my understanding, is that it's a social disorder. It's not a learning or intellectual disorder that's going to affect him. It's a social disorder. It's an awkward thing. But the OCD, obsessive compulsive disorder, that is a psychiatric disorder. And I was. Go ahead.
No. Go ahead. Finish your thought.
Okay. So that is a psychiatric disorder. And because some video footage was released of Bryan Kohberger in his cell, and I'm still not sure whether it was real or not real, but it showed him. It showed that his hands were raw. They were red because of washing his hands. They showed how he was trying to clean his shoes. So the jailmate, I guess, they did a report and talked to him, and they said, oh, he was fine, but his habits, he was taking long showers, always washing his hands and this and that. So there's some support for the fact that he does have OCD, and it's in the court record. So what I'm trying to...
So what? Do you not think if this was such a disorder that affected his ability, they would have to raise competency, that Ann Taylor wouldn't have done it? She pulled out all the stops. She had unlimited funding. If there was something legitimate there, they would have raised it. At best, it's a little bit of mitigation. That's it.
Okay. But in order to make this stick, this is what I'm trying to find out. In order to make this plea deal stick, do you think that the judge had an obligation to ask him about his disorders and whether or not those disorders were affecting his decision to plead guilty?
No.
Okay.
No.
That's all I want.
Listen. No. I mean, I understand you got your high grade in law school, but you do med mal. Probably make a ton more money. Make a ton more money than us little street lawyers doing criminal defense. I assure you that. But the reality of it is, listen, when somebody pleads guilty, the judge just has to be satisfied that they know what they're pleading guilty to. They know the possible penalties of their guilty plea. And 3, that they understand their constitutional rights that they're giving up, right? That they have a right to a lawyer, that they'll continue to have a lawyer through all stages of those proceedings. They can enter a plea of not guilty, make the prosecution prove that case beyond a reasonable doubt unanimously to a jury of people. At trial, the defendant would have a right to cross-examine and test the evidence.
Yes.
And test the evidence at trial. And at a trial, the defendant never has to prove themselves innocent. They never have to prove themselves guilty. The prosecutor prove themselves innocent. That the prosecution always has to prove them guilty. You have a right to subpoena and call witnesses. If they wouldn't come voluntarily, they could be ordered to appear at their own expense or at court expense. And the defendant always has the right to testify at trial or not to testify at trial. And if they choose not to testify, the jury would be instructed that they could not use their silence against them. And if you went to trial and you lost, you'd have a right to an appeal. And other than your right to an attorney through all the stages of those proceedings, you are giving up all those rights. Are you doing that knowingly, voluntarily? Is anybody threatening you to put pressure? And he said, I'm doing it all freely and voluntarily. That's it. It's done. No one's going to undo this. No one is going to undo this.
Yeah. Okay. So actually, I listen to criminal defense attorneys, and you're one of the attorneys I listen to, even though I don't always agree with you. But I understand that knowing criminal law and practicing it is two different things. I mean, I rely on experts. I'm a medical malpractice attorney, and I deal with birth injury cases. And I know about experts. And the one thing that bugs me to no end is that if you need an expert to identify the vehicle that was circling around, you can't even say it parked. If you need two different experts. One is the FBI expert balance, and the other is the defense expert. And the defense expert is paying for an expert. So whenever you have a case in criminal law where you're paying experts to give an opinion, and the jury has to listen to it, I mean, isn't that reasonable doubt in and of itself?
No, I don't think so. I mean, it could be. I guess it just depends on the potential juror. But with all the other evidence, I don't think I would hang my hat. I wouldn't hang my hat on, wow, they need two experts. No.
Wait, said with all the other evidence.
Yes.
What other evidence?
The DNA.
What other evidence?
The DNA on the sheath, his phone turning off,
Right, but
him being there some 23 times before that, all the subsequent actions afterwards of wiping your phone, cleaning your car,
however,
getting it replated.
So, Scott, we're relying on experts for that information. We as jurors cannot determine that on our own.
Sure we can. They determine it every day. Jurors determine that every day.
No, but the jury has to listen to the expert talking about the cell phone towers and how they ping and where he was. This is not something that a juror can determine on their own.
Sure they can. This is such common. I could explain phones
You
pinging.
mean to tell me that I as a juror can look at what's happening and understand the phone pings and say, oh, I think his phone pinged there. No, I would not be able to do that, but for an expert explaining it.
Well, you have to bring somebody in to testify to that. The expert could be a simple analyst saying, I have platted all the data points and put them in the computer, and I put them on this nice little pretty map, and here's the time, and here's that. Yes, that you would require a witness to do that. But jurors decide whether that's credible evidence or not all the time. Jurors decide complex antitrust issues that's not their area of expertise. They decide med mal cases all the time. They're not doctors, but they listen to the evidence, they judge credibility, and they decide who is right and who is wrong, right? Did it occur or not? That's it.
The point I'm trying to make is that a juror has to rely on experts for certain areas in the case where a juror doesn't have the understanding. It's beyond a juror's understanding.
But the jury is given instructions that says you've heard from an expert. You may view their testimony as any other expert or any other witness in the case. You can believe some of it, all of it, or none of it.
Correct.
And so they're the determiners of credibility. And you know as well as I do, they oftentimes have dueling experts. If you're a med mal attorney, you know, whether you're a plaintiff, you've got your doctor saying, negligence occurred. You got the other side, and they probably bring in two doctors to say negligence didn't occur. And so, that's not.
But let's say this. The burden of proof is less in a civil case than it is in a criminal case. So when you have experts talking about critical things about putting somebody to the death penalty, or convicting someone for a murder, when you have experts and the jury has to decide the credibility of each, as opposed to video cameras showing what happened.
What do you think how do you think anyone was ever convicted until video cameras became so prevalent within the last 15 years? They heard from witnesses.
Right.
And they judged the credibility.
Yes. But witnesses are different from expert witnesses.
Yes, because expert witnesses have some technical training or knowledge the general witness would not have, right? Most witnesses testify as to what they saw. That's their testimony, right? They can't testify to what other people said. That would be hearsay. So it's their observations, what they heard, what they observed.
Unless there's an exception, like an excited utterance. But
yes,
that would be hearsay.
Yep. So I don't know. I don't see what the big deal is. I mean, I've tried lots of cases. I mean, I just lost a homicide case the other day. And
Yeah.
it was on videotape, for God's sakes. Didn't need any experts. We're like, hit play. Boom, there it is. We watched it over and over and over again. And, the jury was like, you probably can't chase somebody down and shoot him in the back. Not good self-defense argument.
Yeah.
But that's all we had.
So my question to you is, what do you do to defend people who are on videotape? Not like Kohberger. I mean, Kohberger,
it's tough.
I mean, I have my thoughts.
It's tough.
It's tough, right?
It's very tough, but I've done it. You have an absolute right to make the prosecution prove the case. I had a client once, burglary case, goes into robs a 7-Eleven, literally robs everybody at the 7-Eleven standing in line, like, give him what you got in your pocket. I'll take that Coke can. Goes down to another store, shoots somebody on video. And he's like, I'm going to trial, man. It's not me. And I'm like, literally, like, dude, I'm your attorney, but I'm telling you, that looks like you. I've told this story before. We did that ain't my baby defense. He's like, that's not me. And I'm looking, I was like, I understand it wasn't the best quality, but like, that's you.
Yeah.
Only person that said that wasn't him was his mom. So I brought her in to testify and said, ma'am, I want to show you a picture taken here from the video. Is that your baby, ma'am? That ain't my baby. Well, guess what? A jury of his peers determined, yes, that was his baby. That was her baby. Okay. Juries make those decisions all the time. And guess what? It's so difficult to get 12 people to agree on anything, let alone beyond a reasonable doubt. Jurors take their jobs very seriously. And guess what? If somebody has a doubt, they shouldn't change their mind. But it's one thing to say, well, there's this one fact, and I'm going to go hang my hat on that one particular fact and ignore everything else. And that's why a lot of these people that, watch comment on this true crime stuff is like, man, you guys have never tried a criminal case in your life, have you? Because the reality of it is you just don't get how it all works. And, just because that, it's a couple of questions. That's great. It's like, oh, that's a couple of questions on cross-examination. But is that going to be enough to carry the day where you're going to go and risk spending the rest of your life in custody because of that? No.
Well, yeah. And when you say that people think like they say, I'm going to talk about this one thing and this thing, is it for me? I can't get over it. Well, that Mr. Nye, the state attorney, Idaho state attorney, or district attorney, I guess I should say, Mr. Nye, he said, but for that trace DNA on the knife sheath, and but for the fact that the judge didn't throw it out because the FBI did a search that was not within their policy, we probably wouldn't have had a case. So it seems that the state was hanging on that very, very thin. I say thin, you might disagree with me. And I say thin because I'm not a criminal defense attorney. I will rely on you, totally defer to you. But when you have people, the Mr. Nye saying this, it causes people to think, what a flimsy case. I mean,
then you know what? Then Bryan Kohberger shouldn't have been such a wimp and should have gone to trial and made the government prove their case beyond a reasonable doubt. But it wasn't his attorneys twisting his arm to plead guilty. That was his decision. Right. They couldn't even go and try to negotiate that disposition without his permission to do so, or knowing that he would in fact take life without parole. So at the end of the day, people can have all their theories and what ifs, but at the end of the day, let's face it, Bryan Kohberger was a wimp. He couldn't stand the pressure of trial.
Yes. I understand what you're saying. Yes. And whatever reason he couldn't withstand the pressure of trial, that's neither here nor there. And the other thing, well, the last question, because I don't want to keep you here forever, because I could talk forever. But the last thing I want to say is Ann Taylor was making a record about how she couldn't be effective counsel if she didn't have more time, because she was trying to get the witnesses together regarding the mitigation phase, and she was having difficulty with that. And
you know what? She wasn't having difficult getting mitigation witnesses because they weren't cooperative. She just didn't have any mitigation witnesses. She wanted to keep digging forever. You do litigation. Litigation is a black hole. That's why it burns people out, because there's always something you can go double check, maybe go re-interview somebody, one more thing to go back and reread and, see how it's going to change it. It's a black hole. The reality of it is she had nothing. And when they had the mitigation witnesses that were endorsed, they turned out to be a bunch of nothing burgers. They're like, yeah, I was like in his karate class and, I sparred with him, but I haven't talked to the guy in like 10 years. So I'm not really sure why I'm on the witness list. You know what I mean? They had nothing. They had nothing. And they knew that they were going to go to trial. They had a very strong feeling that they were going to lose at trial. And they also had a very strong feeling that if he was convicted, that he was going to get the death penalty. And most death penalty lawyers, their only goal is to get death off the table. Mission accomplished for Ann Taylor. Bottom line.
Yeah, that's what I said.
Listen, she is competent and effective counsel. They litigated that stuff. Did she probably look at every piece of discovery? No, but I bet somebody on that team looked at everything. But it all came back to one thing. They got nothing. They had nothing. And, I would check myself. If I was his attorney, I would have gone in there, checked myself at the Psychosis Hotel, the penthouse suite, and be like, yeah, we got it here, man. And other than that DNA and your phone evidence and maybe a questionable ID and, the consciousness of guilt stuff afterwards, where you dumped everything, you cleaned all your computers, you cleaned your car meticulously. Other than that, they got nothing.
But Scott, now you're relying on experts, because experts are the ones who are going to tell you that he cleaned everything, and we don't have testimony from those experts. And I know that.
Well, they had his phone, I think, where he had found people to detail. He was getting cars detailed or looking to detail them. He may have done it himself for all we know, but his car was rather clean.
These so-called experts are not under oath when they're saying this.
Sure they are.
So
they'd be under oath. They would be under oath in court saying it.
Could be, but
no, they will be.
It now.
Every witness, do you swear and affirm under the pains and penalty of perjury that the testimony you're about to give in the above action is the truth, the whole truth? Yes, I do. They all take the oath.
And did that happen in this case?
No, because Bryan Kohberger pled guilty.
Guilty. So the experts are allowed to talk about what they want, but it's not under oath. So that's my point. So I am
all right.
Very reasonable.
Obviously.
I have. No, I'm reasonable. I listen to you, and I always say, listen to criminal defense attorneys. Go look at, Scott Reich. I do. I listen to you.
I appreciate that.
Personally. What?
I appreciate that. Thank you.
Yeah, no, I do, because I appreciate experience, because experience is nothing like, academia. You could get the highest grade in a certain subject, but if you don't practice it in law, it doesn't work. And I know that because I'm a medical malpractice attorney, and people always want to sue doctors and hospitals, and they don't understand, and it's very frustrating. But this case is just, I have conflicted views, and I want to, it's just a very difficult case. I don't know.
I understand, but at the end of the day, he pled guilty, and that's the ultimate confession. That's the ultimate confession. And there may be things that you can nitpick here and there, but at the end of the day, he pled guilty, and all the other stuff at that point doesn't matter. It doesn't matter anymore. Had he gone to trial, perhaps, but he wimped.
Yeah. Yeah, I agree. And
All right.
the appeal is not going to go.
No, there's not going to be any appeal. There's nothing to appeal.
No,
If
I
he
know.
appealed,
He was
all
caught.
the charges would come right back. And do you think his case got
Yeah,
any
it makes
better? No. He's done. He's gonna go to prison. More than likely, something bad will happen to him in prison. Maybe not now, next week, maybe years from now, decades from now, but somebody will probably get him.
Yeah. Well, it was nice talking to you, and
Thank you. Thanks for
I
the
just
call.
I needed to express my thoughts, and
I appreciate
even
it.
though I'm arguing with you.
I appreciate it.
do
That's why we do our
understand.
call in. That's why we do our call in line. I enjoy it. I love the banter back and forth. I love it. So thank you.
But even though it's hard, like it's really hard because there's a lot of things that cause me to question things. But you just got to realize he pled guilty, and it was for a reason.
Yep. It's over.
Yeah.
Yep. Thanks.
All right.
Have a good night.
Good night.
All right, real quick, Frank. So you got the video, right? That shows the beer pong table that she was talking about.
Yep.
All right, let's roll it real quick here. Let's take a look. So this is a body cam, right? Knife on the beer pong table. Doesn't appear to have any blood-like substance on it.
Okay.
Yep, there it is.
Right there.
Okay. That was my recollection of the knife. I remember seeing it. I remember seeing still photos of it.
Yeah, you can kind of see.
Looks like a typical house. And I don't remember it being what's what I'm looking for.
There you go. You can see the knife there.
Yeah, but I don't remember another video where it's missing. Yeah. And there's nothing to indicate that that was a murder weapon, because if they thought that was a murder weapon, we would have heard about it. They still believe that the K-bar was the murder weapon. So, I understand. I mean, it would have been, hey, nobody would have loved for this case to go to trial more than I would have. All right. But the reality of it is it's never going to happen. He pled guilty. All right. Do we have time for one more call, Frank? Or was there one more call? They drop off.
Yeah.
All right. See who we got. Who's next? Hello.
Hi, I have a quick question being from Colorado. Obviously, Bryan, when he was sentenced, waived his right to appeal, but we all know he could appeal. He just wouldn't be successful. But could the state governor commute or give him clemency on his sentence, like what happened in the Chuck E. Cheese murder case, where Hickenlooper and Polis stepped in and
Yeah, I mean, the
granted
governor, the governors
communication?
of each state have the power for pardons and any other form of clemency that they deem appropriate, just like the president can issue pardons as it relates to federal convictions, and they can grant clemency by reducing sentences. Yes, you're right. For example, in the Chuck E. Cheese murder here, I believe it was Hickenlooper gave him clemency. And then I think they also gave life sentences without the possibility of parole before the legislature passed the repeal of the death penalty here in the state of Colorado. So yes, the governor could do that. I can't imagine that would not be a good political move for any politicians. I don't care what side you're on. And he didn't get the death penalty. So, everyone's going to no, I don't think anybody's going to come to Bryan Kohberger's aid and say, well, maybe you should only serve 2 life sentences or maybe 40 years. I don't see that happening at all. That'd be it.
Understood, but I mean, theoretically, 30 years from now, some hard, subbed person who could be governor could
Absolutely.
get the sentence, right?
Absolutely.
And is that probably why a lot of the families of the victims wanted the death penalty?
Yeah. And, like I said, yes, the governor could do that theoretically. I wouldn't see it as a good political move, but yeah, it's always possible. I think one of the biggest mistakes they made here in Colorado, and I'm a criminal defense lawyer, is that the legislature, not by a vote of the people, remember, like California, right? One of the most left-wing states in the country has a death penalty because they put it to the voters. Here, I think the legislature knew that if they allowed the citizens to vote on it, that the death penalty would be on the books. But they did it themselves
Gotcha.
because they thought it was the touchy-feely righteous thing to do. I think it's actually a disservice to prosecutors to have that. And frankly, it's a huge bargaining tool in extreme cases. And, so what's the difference now? You kill one person, you get life without parole. You kill 2, 3, 4, 5, you stab, a bunch of people in prison. Okay, now we're really going to keep you in prison for the rest of your life? It makes no sense.
It's just like the new law that's passed with sexual assault. You can sexually assault 10 children one time and get parole, but you can't sexually abuse somebody 10 times. Then it's different.
Yeah,
right?
I mean, there's lots of crazy stuff going on out there, but yeah, I mean, it just makes no sense to me. And like I said, I mean, I've only done one case that they were going to go death. We convinced them not to. So it wasn't a trial. We ultimately went to trial and had some pretty bad facts. And, 2 dead bodies, a sexual assault and an attempted murder. A little tough to overcome, particularly with a co-defendant testifying against you. And, that pesky DNA from a cold case where there was no witness, there was no video, right? So when I talk about, I know
Right.
a little bit about DNA, I know about homicide cases. I'm not saying this because I, think in my mind I should go try one day. I've done them. I did one 2 weeks ago and I lost. All right. That's just the nature of this business. Sometimes you got to go try it when there is no offer. You know what I'm saying? And you come up with what you got, and maybe you raise reasonable doubt. Maybe you make appellate issues. That's what you do. Sometimes the client wants the deal. You take the deal, even if you think you got a shot at it. But that's the way it goes. All right.
Well, thank you. You taking my call. Thank you.
Thanks for calling in. Have a wonderful evening. All right, ladies and gentlemen, that's all we have for you for this evening. Can't believe it's already 2 hours. Man, that goes by so fast, doesn't it, Frank? All right. Have a wonderful evening. Thanks for watching. We know you have lots of other things you could do, so we appreciate you taking the time to hang out with us, call in, chat, just listen. We appreciate it. Hopefully you enjoyed it. Maybe you learned something. Have a wonderful night. But remember, never forget, the Constitution matters.